No one is ever pleased at losing their job for whatever reason, but if they consider they were treated improperly, they have a legal right to challenge that. Because to dismiss an employee, an employer, there are only 6 permitted, potentially fair reasons to do that. So the employer has to satisfy the requirements of the Employment Rights Act. First of all, to identify the potential reason, and that's the important terminology in that, potentially fair reason. Then he has to satisfy the requirement that it was actually fair what he did in dismissing the employee, and a failure to satisfy that requirement makes it prima facie unfair, so then it's potentially unfair dismissal. And as I say, no one likes to lose their job, so obviously the employee is aggrieved in any sort of sense. But then there could be potentially other aspects, for example, like gross misconduct, if the employee is disputing that. If he was dismissed for that reason, and it wasn't established as an actual fact that's what happened, then obviously he has a grievance there. Gross misconduct means you can be summarily dismissed without notice or notice pay, so there's very serious implications, and generally it's for reasons of misconduct or dishonesty or violence, very serious things, and very serious potential impacts on the individual's career. So obviously if they feel they weren't properly treated, they'll come and see me. If an employee contacts my office and feel they have grounds for a complaint, obviously for me to advise them properly I need to see as much documentation, whatever exists, and to hear basically their side of the story, because they can be quite convinced they have solid grounds, but that may not be the case. So rather than instructing me, full instructions, they have a facility, we have a facility for them to come to me and see me for half an hour. That's a half an hour of my time, which is at a fixed rate of £80, including VAT. And I can generally identify within that half hour whether or not there's a potential claim or complaint that can be made. And based on my advice I would give to the employee, then it'll be a decision for them whether they want to pursue it. A redundancy is one of the permitted, potentially fair reasons to dismiss an employee. Once a genuine redundancy situation has been identified by the employer, he then has to follow due process to actually dismiss an employee. Now, due process is not statutorily defined, but this is what gives the employers difficulty. They have to show that they carried out a fair procedure, a fair process, and they're transparent at all times. And to make an employee redundant has to be shown to be the actual last resort. That's the last resort scenario. So if they actually end up doing that, they have to be able to show how they carried out a thorough and proper procedure. Otherwise, it can be seen to be manifestly unfair, and it turns it from a potentially fair reason, i.e. redundancy, into an unfair dismissal. Well, anyone can be made redundant as an employee, but what obviously interests the employees, if they are going to be made redundant, are they going to receive any sort of payment? Now, to receive the statutory redundancy pay, you have to have worked for a minimum of 2 years for your employer. And then the statutory requirements that you get 1 week's pay for every year over the 2 years. So for example, if you work for 10 years, you get 10 weeks pay. So if you've worked for less than 2 years, you can still be made redundant. But what that means is you're not entitled to redundancy payment as such. All you'd be entitled to there would be your notice pay. Whereas over the 2 years, you get your redundancy pay and your notice pay. In most cases then, where the disciplinary proceedings have been started or going to be instigated against the employee, I would strongly recommend they would come and see me for advice to protect their own position. Because the earlier you get advice, the earlier you can address issues. The longer you let things go, it can be to your complete detriment. Where I strongly recommend to employees is to ask their employers for a written contract, because the difficulties arises when there's problems. If you don't have a written document to refer to say this is my terms and conditions, here's my duties, there's what I'm obliged to do, there's what you're obliged to do. It's a two-way street, and it's an exercise in knowing where you stand. And I have employees coming into me frequently and saying, I don't have a contract of employment. You do. It's just if you don't have it written, doesn't mean you don't have it. This is where difficulties start, because then it boils down to your word, the employee against the employer, turns into an argument. You've no written documentation to refer to, makes it very difficult. But what the employer must provide to an employee is what's called a Section 1 statement under the Employment Rights Act, and that must be provided within 2 months of the new employee starting. A Section 1 statement is best described, I think, as a general outline, like bullet points of this is your general terms and conditions, this is where you work, there's your hours, there's your pay, to give you some indication of what your actual terms are, and that must be provided to all employees. If the contract of employment comes on board after that, the idea of that is to flesh that whole thing out so you have a complete document. So it's quite surprising the amount of employees out there who sort of come from basic belief, no, I haven't got a contract of employment, he doesn't give me one, I don't have one. You do. And you have the full protection of the Employment Rights Act as an employee.